Hello dear students, today I welcome you with a new topic, that is Judiciary US and India. The lecture will try to analyze judiciary as a branch of government. This lecture will also analyze the working of judiciary in USA and India. It will also try to examine the working of judiciary in both the countries, that is USA and India. Before the advent of the democracy, sovereign powers encompassing legislature, executive and the judicial functions were exercised by a single authority. With the advent of democracy, which implies governance with the consent of the governed, the need of the constitution was felt. The distinction between the legislative, executive and judicial functions was an important feature of a written constitution. Legislature enacts laws which are enforced by the executive, while the judiciary interprets and implements these laws. There is a serious threat of public interests getting undermined if the legislative, executive and the judicial functions are confined in a single person or institution. If the authority that passes the laws is vested with the power to interpret and enforce the same, the result would be tyranny. Judiciary not only punishes the violators of law, but also safeguards the citizens against the authoritarianism of the state. Judiciary has been entrusted with the responsibility to safeguard the rights of the citizens in almost all the civilized nations of the world. Judiciary has the responsibility of the interpretation in regard of the various articles in the written constitution, like India. It has the power to declare any law or ordinance illegal which goes contrary to the letter and the spirit of the constitution. In federal structure, the judiciary has a special importance. Here, the governments at the center and the state governments are not supreme. They have to work in their own affairs as per the constitution. If there arises any dispute between the center and the states or between the states, the judiciary has to resolve the disputes. The judiciary safeguards the federal constitution. Therefore, the judiciary has been accepted as the guardian of the constitution in federal states. The judiciary is also called the custodian of the constitution. Now we will discuss judiciary in USA. The US government is divided into three branches: legislative, executive and judicial. All the three have certain duties and responsibilities. No single branch has more power than the others, which means they must work together in order to get things done. The judicial branch runs the federal courts, ranging from district courts to the Supreme Court, which is in charge of interpreting laws in relation to the Constitution. In the United States judicial system, the Supreme Court is the final authority on the interpretation of the federal Constitution and all statutes and regulations created pursuant to it, as well as the constitutionality of the various state laws. In the US federal court system, federal cases are tried in trial courts known as US district courts, followed by appellate courts and then the Supreme Court. State courts, which try 98% of litigation, may have different names and organization. Trial courts may be called Court of Common Plea, appellate courts, superior courts or Commonwealth courts. The judicial system, whether state or federal, begins with a court of first instance, is appealed to an appellate court, and then ends at the court of last resort. The US Supreme Court is the most powerful court in the world. The United States federal courts make up the judicial branch of federal government organized under the United States Constitution and laws of the federal government. Article 3 of the Constitution provides for the establishment of Supreme Court and permits the Congress to create other federal courts and place limitations on their jurisdiction. Congress has the authority to regulate the judicial system as a whole, though much of this power has been devolved to the courts themselves. The courts were established through the Judiciary Act of 1789, which provided for the first Article 3 judges who are appointed by the President with the consent of the Senate to serve until they resign or impeach and convicted, retire or die. Congress also has the power to establish other tribunals to assist in the execution of the powers. These are generally specialized courts. Judges normally serve fixed term. With limited exceptions, they cannot render final judgment in cases involving life, liberty, and private property rights, but may make preliminary rulings subject to review by Article 3. The Supreme Court of the United States is the highest federal court in the United States. It has ultimate and largely discretionary appellate jurisdiction over all federal courts and over state court cases involving issues of federal law, plus original jurisdiction over a small range of cases. In the legal system of the United States, the Supreme Court is the final interpreter of federal constitutional law. Although it may only act within the context of a case in which it has jurisdiction. The court meets in the United States Supreme Court building in Washington, D.C. and consists of a Chief Justice and 8 Associate Justices who are nominated by the President and confirmed by the Senate. Once appointed, justices have life tenure unless they resign, retire, take senior status, or are removed after impeachment, though none has ever been removed. In modern discourse, the justices are often categorized as having conservative, moderate, or liberal philosophies of law and of judicial interpretation. Each justice has one vote, and while many cases are decided unanimously. Now coming to judiciary in India. The founding fathers of the Indian Constitution were greatly influenced by the theory of separation of powers, which they borrowed from American Constitution. Justice is the very first objective in the preamble of the Indian Constitution. It declares that sovereign democratic Republic of India has to secure to all its citizens justice, social, economic, and political. The primary, though not exclusive instrument of justice is the judiciary. The judiciary has assumed only such roles as would enable it to fulfill the ideals of the Constitution. The role of the courts is not just to interpret laws, but to safeguard the rights that legitimately belong to the people. Constitutional perspective of judiciary in India. The Constitution of India deals with judiciary in Chapter 4 of Part 5 and Chapter 5 of Part 6. Chapter 4 bearing the heading, the Union Judiciary, that starts from the Article 124 to 147. Elaborately deals with the Supreme Court of India, appointment of judges, the jurisdiction of the court, and the other details. Article 213 to 231 incorporates provisions concerning the High Courts, appointment of Chief Justice and other judges, jurisdiction, and other details. To ensure the independence of judiciary, elaborate safeguards regarding appointment of judges, their tenure, salaries, and procedure for their removal are incorporated. The adoption of a federal system, the Constitution of India has not provided for double system of courts as in the United States. Under Indian Constitution, there is a single integrated system of courts for the union as well as the states, which administer both union and state laws. At the head of the entire system stands the Supreme Court of India. Below the Supreme Court stands the High Court, and in the different states and under each High Court, there is a hierarchy of other courts which are referred in the Constitution as subordinate courts. That is, courts subordinate to and under the control of the High Court, which is mentioned in Article 233 to 237. How Supreme Court is considered as the guardian of the Constitution. The essence of the federal Constitution is the division of powers between the center and the state governments. The division is made by a written constitution, which is the supreme law of the land. Since language of the Constitution is not free from ambiguities and its meaning is likely to be interpreted differently by different authorities at different times, it is but natural that disputes might arise between the central and its constituent units regarding their respective powers. Therefore, in order to maintain the supremacy of the Constitution, there must be an independent and impartial authority to decide disputes between the center and the state or the states inter se. This function can only be entrusted to a judicial body. The Supreme Court is the final interpreter and guardian of the Constitution. In addition to the above function of maintaining the supremacy of the Constitution, the Supreme Court is also the guardian of fundamental rights of the people. Truly, the Supreme Court has been called upon to safeguard civil and minority rights and plays the role of guardian of the social revolution. It's great tribunal which has to draw the line between the individual liberty and the social control. It is also the highest and final interpreter of the general law of the country. It's the highest court of appeal in civil and criminal matters. Now we'll discuss the impeachment of a judge in Indian Constitution. The procedure for the removal is contained in Article 124, Clause 4, which commonly is called the impeachment procedure for removal of a judge. The combined effect of Article 124, Clause 4 and the Judges Inquiry Act 1986 is that the following procedure is to be observed for the removal of a judge. This is commonly known as impeachment. First, a motion addressed to the President signed by at least 100 members of the Lok Sabha or the 50 members of the Rajya Sabha is delivered to the Speaker or the Chairman. Second, the motion is to be investigated by the committee of 2 judges of the Supreme Court and a distinguished jurist. Third, if the committee finds the judge guilty of misbehavior or that he suffers from incapacity, the motion with the report of the committee is taken up for consideration in the House where the motion is pending. Fourthly, if the motion is passed in each House by majority of the total membership of that House and by a majority of not less than 2/3 of that House present and voting, the address is presented to the President. Fifthly, the judge will be removed after the President gives his order for removal on the said address. The procedure for the impeachment is the same for judges of the Supreme Court and the High Court. Now coming to the jurisdiction of the Supreme Court. Now firstly, how Supreme Court is to be a court of record. According to Article 129, the Supreme Court shall be court of record and shall have all the powers of such a court, including the powers to punish for the contempt of itself. Second, original jurisdiction of the Supreme Court. Subject to the provisions of the Constitution, the Supreme Court shall, to the exclusion of any other court, have original jurisdiction in any dispute between the Government of India and one or more states, or between the Government of India and any state or states on one side and one or more states on the other, or C, between two or more states. The Supreme Court, in its original jurisdiction, cannot entertain any suits brought by private individuals against the Government of India. The dispute relating to the original jurisdiction of the court must involve a question of law or fact on which the existence of legal right depends. This means that the court has no jurisdiction in matters of political nature. The term legal right means a right recognized by law and capable of being enforced by state, but not necessarily in a court of law. Now coming to the appellate jurisdiction. Under Article 132, the Supreme Court is the highest court of appeal in the country. The writ and decrees of the court run throughout the country. It can be truly said that the jurisdiction and powers of the Supreme Court in their nature and extent are wider than those exercised by the high courts of any country in the Commonwealth or the Supreme Court of the USA. The appellate jurisdiction of the Supreme Court of India can be divided into four main categories: constitutional matters, civil matters, criminal matters, special leave to appeal. Now, firstly, we will discuss the constitutional cases. Constitutional cases involving substitutional point of law regarding interpretation of the Constitution can be appealed in the court if the High Court certifies under Article 134, Clause A that the case involves substantial question of law as to the interpretation of the Constitution, and if the High Court does not give such certificate, the Supreme Court also may, in its discretion, grant special leave to appeal under Article 136 of the Constitution. Coming to the civil cases. In civil cases, there can be appeal from the judgment decree or the final order of the High Court if the High Court under Article 134 Clause A, either on its own or on the oral application of the aggrieved party, certifies that the case involves the substantial question of law of general importance. In the opinion of the High Court, the said question needs to be decided by the Supreme Court as per Article 133 of Indian Constitution. In case the High Court does not give such a certificate, then the Supreme Court can also give special leave to appeal in civil cases under Article 136 of the Constitution. Now coming to criminal cases. In criminal cases that's mentioned in Article 134, there can be appeal from any judgment, final order or sentence given by the High Court if the High Court has an appeal reversed an order of acquittal of an accused person and sentenced him to death, or has withdrawn from the trial before itself any cases from any court subordinate to its authority and has in such trial convicted the accused person and sentenced him to death, or certifies under Article 134 Clause A that the case is fit for the appeal to the Supreme Court. It means in criminal matters, ordinarily, the High Court are the final courts of appeal. And then coming to appeal by special leave. While the Constitution provides for the regular appeals to the Supreme Court from decisions of the High Court in Article 132 to Article 134, there may still remain some cases where justice might require the interference of the Supreme Court, with the decision not only of the High Courts outside purview of Article 132 to 134, but also of any other court or tribunal within the territory of India. Such residuary power outside the ordinary law relating to appeal is conferred upon the Supreme Court by the Article 136. It vests in Supreme Court a plenary jurisdiction in the matter of entertaining and hearing appeals by granting special leave against any judgment or order made by any court of tribunal except military tribunals in any proceeding, and the exercise of power is left entirely to the discretion of the Supreme Court, unfiltered by any restriction, and this power cannot be curtailed by any legislation short of amending the article itself. This wide power is not, however, to be exercised by the Supreme Court so as to entertain an appeal in any case where no appeal is otherwise provided by the law of the Constitution. It is a special power which is to be exercised only under exceptional circumstances, and the Supreme Court has already laid down the principles according to which this extraordinary power shall be used. For example, when there has been a violation of the principles of natural justice. Now coming to advisory jurisdiction. Article 143 provides that if any time it appears to the President that a question of law or fact has arisen or is likely to arise, and the question is of such a nature and of such a public importance that it is expedient to obtain the opinion of the Supreme Court upon it, he may refer the question for the advisory opinion of the court, and the court may, after such hearing as it thinks fit, report to the President its opinion thereon. Under Clause 2, if the President refers to the Supreme Court matters which are excluded from its jurisdiction under the provision to Article 131, the court shall be bound to give its opinion thereon. Now coming to the most important part of this, that is the writ jurisdiction of the Supreme Court and High Court. The Supreme Court as well as the High Courts possess what may be called an extraordinary jurisdiction under Article 32 and 226 of the Constitution respectively, which extends not only to inferior courts and tribunals but also to the state or any authority or person endowed with state authority. The peculiarity of this jurisdiction is that, being conferred by the Constitution, it cannot be taken away or abridged by anything short of an amendment of the Constitution itself. As has already been pointed out, the jurisdiction to issue writ under these articles is larger in cases of the High Court, in as much as while the Supreme Court can issue them only where a fundamental right has been infringed, a High Court can issue them not only in such case but also where an ordinary legal right has been infringed, provided a writ is a proper remedy in such cases according to well-established principles. The High Court also has the power of issuing direction, order or writs, including the writs in the nature of habeas corpus, mandamus, prohibition, quo warranto or certiorari, or any of them against any person or authority within its territorial jurisdiction for the enforcement of the fundamental rights or for any other purpose, which means for the enforcement of any other legal rights. It means, like Supreme Court, the High Court too has original jurisdiction to issue any of the writs for the enforcement of the fundamental rights. The only limitation is that the writs can be issued either to persons and authorities within the territorial jurisdiction of the High Court or to persons and authorities notwithstanding the residence of such person or seat of such government or authority. If the cause of the action wholly or in part arises within its territorial jurisdiction. To conclude, we can say that justice is the basic human law for any civilized society to function. Upholding the law is in fact the first essential, the first guidepost of a modern democracy. No nation, no state can survive unless it provides an efficient justice delivery system that can elevate the concern of the people within responsible time frame. Thus, the judiciary is that branch of government whose function is the interpretation of laws and the administration of justice. This is all for today. Thank you.